Commissioners of Majesty's Revenue and Customs against NCL Investment Limited and another.
Yes, Mr. Ghosh.
I'm grateful. My Lords and my Lady, good morning. May it please the Court. I appear with Mr. Bremner and Mr. Bradley for the Crown. My learned friend, Mr. Maugham, appears for the respondent companies. Please, with the Court's permission, may I frame the issue shortly and then just then make my submissions. Put short, we have a group, a holding company, Smith Williamson Holdings, SWHL. It has two subsidiaries. These are the respondent companies. They've got employees. One is NCL Investments. The other is Smith Williamson Corporate Services Limited. So these are subsidiaries of SWHL. And we have an employee benefit trust. We've got an EBT. The EBT trustee grants an option, or options in the plural, to the subsidiaries' employees, so the employees of NCL and SWCS. An accounting debit arises in NCL and SWCS. Now, the option was granted by the EBT trustee. The shares that the option permits these employees to acquire, they're in the parent company. They're in SWHL. So, NCL and SWCS, the respondent companies, they're not parties to this option grant. Nevertheless, they book an accounting debit, and I'll address the Court as to the nature of this debit later on in my submissions. But they book a debit. And what's an issue is whether this debit in these respondent companies is deductible for corporation tax purposes. That's the issue for this Court. There is also in this case, but not in many of the cases behind it, what's called a recharge. So the options granted by the EBT trustee to NCL and SWCS employees, the shares are in the parent company, and in this case, there's a charge or a recharge by parent to these two companies of an amount equal to the value of the options. And for the reasons I'm going to come on to in my respectful submission, that recharge is irrelevant to this case. Now, that was supposed to be common ground all the way through this litigation, that the recharge is irrelevant. And Mr. Maugham shakes his head. I'll show you why it was supposed to be common ground, and I'll, in my respectful submission, make good that it is irrelevant, the recharge, on any view. So what we're looking at is this accounting debit from the relevant accounting standard IFRS 2, that on the grant of this option, you have this debit to the profit and loss account of the two respondent companies. Question, is this debit deductible for corporation tax purposes? With the Court's permission, if I make my submissions on Section 1290 of the Corporation Taxes Act first, and the reason that I hope is efficient is that when I make my submissions on Section 1290, I do not have to interrogate the nature of this debit. That is relevant and important for the second set of submissions I'm going to make about the relationship of accounts and tax. But the nature of the debit, the reason why it arises for accounting purposes, is not relevant for Section 1290 purposes. But the thing I do want, please, the court to hang on to is that the debit arises because of the issue of the option by the EBT trustee. That's what results in accounting entries. And in my respectful submission, all of the courts below, the first tier tribunal, the upper tribunal, and the Court of Appeal, lost sight of that.
Well, you'll no doubt come to this, but the accounting logic, as I understand it, is that the debit actually reflects the consumption by the company in question of its employees' services.
No, I don't accept that's the accounting logic. Can I take the short,
That's
my
the
lord?
FTT paragraph, well, you may say they're wrong, of course. I think it's the FTT paragraph 24.
I will take the court to this, my lord.
Okay.
If I may just take this short, with the court's permission, because this will distract from my 12.
This is the revenue's evidence.
Please, may
Mr. Henworth said, and I agree, that when the EBT, I'm looking at page 180. So Mr. Henworth, the revenue expert, said, and I agree, that the Accounting Standards Board is recognising that when the EBT trustee granted share options to employees, the appellants should be obliged to record an expense relating to the consumption of employees' services as part of a share-based payment transaction that involved the options being granted.
Please may I respond, and then may I respectfully ask the court to hold the thought of my response, and I will return to this, my lord. The accounting logic is this. First of all, the EBT is treated as acting as on behalf of SWHL. It just is, and I'll show you why, but that's how the accountant's treated. The EBT trustee is treated as acting on the behalf of the parent company. That's an assumption made by IFRS 2. My Lord Briggs is looking puzzled. A lot of this is Alice in Wonderland stuff by the draftsperson of IFRS 2, but the EBT trustee is treated as acting on behalf of SWHL. That's point one. What the draftsperson of IFRS 2 thinks happens when an equity instrument, an equity option, is issued by a company, which here includes the EBT trustee, is this. The accounting logic goes like this, and I will make this good, my lord. They say, look, generally speaking, when companies issue equity options for cash, that is recognized in the financial statements, in the financial accounts. When we think, when equity instruments, like an option, is issued to employees, that should also be somehow recognized in the accounts. So that's why I'm saying we start with the issue of the option. How do we recognize it? Because nothing's come out the company. It's an option. There's no outflow of resources, no outflow of money, nothing of that nature.
Well, there is, but it's not recognized by the accounting convention.
Do you mean the recharge?
Yes.
Can I come to that? And I don't accept that there is, but for reasons that I will address. I'll do it now, and then I'll do it again when I come to my accounting submissions on the accounting. So just so that you know, I don't accept that it's an outflow of resources. But sticking with the option, there is the draftsperson of the accounting standard recognises there is no outflow of resources, there is no outflow of money, assets, anything of that nature. So how, if we want to recognise this, should we recognise the issue of this option? Answer, they say, the consideration for this option should be treated as the incentivisation of the employees who get them. However, that sort of consideration doesn't merit the recognition of being an asset on the balance sheet. It would be wrong, misleading to recognise, if we're treating the consideration of the issue of that option as the incentivisation of employees, you don't get to book that as a balance sheet asset. Why? Because they're consumed on receipt. Now that's where it comes in, the acknowledgement. that sort of receipt, that sort of consideration for the option doesn't last. It's consumed on receipt. It's not received, then spent. It's not like getting cash, which you then spend. It combusts on receipt. So where does the debit go? Not as a balance sheet debit asset. It goes to P&L account. Now, in this case, because the option was granted by not the two respondent companies who had the employees, but the parent company, I'm just going to say it's the parent company rather than keep saying it's the EBT, by the parent company, the accounting logic was, okay, what's happened here is that the parent company has granted an option to its subsidiaries' employees. So, the accounting logic is it's made a gift to its employees, a capital contribution. And that's why the accounting logic is, because this option has been issued, and I keep saying, and I'll carry on saying, I'm going to make this good, this equity option has been issued, the accounting for the parent is credit liability to equity, because I might have to issue shares. Debit, increase in value of my investment subsidiaries, because it's their employees that have been incentivized. So you do get to recognize that as a balance sheet asset. What about the subsidiaries, which is what this case is about? Subsidiaries, credit capital contribution, my parent has made me a gift. Debit what? Well, the nature of this contribution is the incentivization of my employees. I don't get to book that as a balance sheet asset. It's consumed on receipt. Therefore, the relevant debit goes to the profit and loss account. There's nowhere else to put it. Now, the intuition, which I'll show you when I get there, when I get to my accounting submissions, is that's why you start with this edifice. It starts from not a consumption of employee services. That's not where you start. That's the mistake the courts below made. You start from the issue of the equity option. How do you book the consideration for that? Because we want to reflect it in the accounts. Answer, the thing you get is incentivization of employees treated as consumed on receipt. You can't put that in the balance sheet. We're not going to let you put it into profit and loss, recognizing expressly that, and I'll come to the recharge, but at the moment, no outflow of resources, no money. Now I'll come to the recharge, and I don't accept this an outflow of resources. Why? The recharge was treated as a repayment of the capital contribution. That's how it was accounted for, and that's what it is intuitively. So the intuition here, which is reflected in the correct accounting, is that parent co makes a gift by issuing this option and agreeing to use its shares to satisfy these options if they're ever exercised. The gift is in the nature of incentivization of the subsidiaries' employees.
Why do you call it a gift when the value of the options is paid?
It's not paid yet, my lord. Please may I answer this? And that should show why it's not a gift. The grant of the option is a gift. Nobody's paid for that yet. Now I'm coming to the recharge. The recharge is separate. It's once that option has happened, what the accountants are saying is if there's a recharge, it is treated as the repayment of a capital contribution. So the way the accountant looks at it is to say, let's say, and this is exactly...
Oh, you're sort of, as it were, running with the hare and the hounds. You know, you're relying on the accounting treatment of the recharge to say that this isn't actually any cost that's incurred by the subsidiary. They receive a gift. But then you disown the accounting convention for the way the the option, the grant of the option is treated in the accounts.
I'm not disowning anything. I'm saying that we start chronologically with the grant of the option. That's the first thing you start with. And in many of these cases, standing behind this case, that's all you've got. And
but it was not the case. Obviously, we're concerned for the case in front of us.
But even in this case, that's what the accountants start with. And that's what explains the accounting in this case, because the accountants start with the series of doubled entries that relate to the grant of the option. And they treat the recharge as separate. And what they're saying, and put another way, there wouldn't be a recharge if the option hadn't been granted. So you need to start with the option, because absent option, there's no recharge, there's nothing to recharge. So I'm not, in my respectful response to my Lord Reid, who asked very, very nicely, am I running with the hares and hunting with the hounds? No, I'm not at all. I'm saying there's a grant of an option that generates a series of accounting entries which the revenue can live with. We say there are reasons why those accounting entries, absent recharge, don't get you a tax deduction. But even if you look at the recharge, what it's doing is repaying a capital contribution. It's the parent saying, I have granted an option worth 100, pay me 100. So neither parent nor sub is up or down. And that's why I say, my lord, there's no net outflow of resources. You've given me something, it's combusted on receipt, but you said, well, I've given you that now, it's a contribution. Actually, that contribution, I want paid for it. And I say, all right, here's the 100. The thing you've given me is still combusted, so the debit in P&L is untouched, even after the recharge. And I will make this good. I promise. I will make this good. But that is why, if you start with the proposition, I've got a debit. That debit is consumption of employee resources. Then there's a kind of tsunami, which is pretty much what I got. Well, then of course it's wholly and exclusively for the purpose of the trade. Of course it should be deductible. But that's not the right place to start. That debit is consideration for the grant of the option. And the recharge is not, for the reasons I've just given, a net outflow of resources. It's saying you've given me something worth 100, but now you're saying pay me, have the 100. And that is reflected in the accounts. So, as it happens, how the recharge is reflected in the accounts in the parent company, if you remember what I'd said was, on the grant of the option, it was credit liability to equity, debit investment in assets. I've made a capital contribution to my subsidiaries. For the parent on the recharge, it was credit investment in subsidiaries, because that capital contribution is being reversed. Debit cash if they're paying me money, or debit a receivable if they owe me the money. The parent is neither up nor down. What about the subs? I've already said. The original grant of the option, you've made me a contribution, thank you very much, parent co. Credit capital contribution. Debit what? I'm not allowed, I've said it so many times now, apologies, but I'm not allowed to book that as a balance sheet asset. It doesn't last, because the thing you're giving me is incentivizing my employees. Debit P&L, because that's what the accounting standard is telling me to do. Now that you're saying this, that I have to pay you, it's credit cash, debit capital contribution, because that's being reversed, credit cash, or some sort of liability to shareholders if it's a loan. But all of this is generated not because you start from the proposition that I am consuming employee services. It starts because somebody's issued a share option. And the draftsperson of IFRS 2 is struggling to say, because he or she wants to book that in the accounts of how do I do it. I wonder, having said all that, please may I ask you to hold that thought and turn to 1290, because we don't need to worry about any of this when we're looking at 1290. That was a question, not a statement. If it's only with the court's permission, if I please may now do that. But of course, I'm going to be coming back to this to interrogate the nature of this debit. And this is a promise. I will show you word for word. This is how even the FTT that found against me recorded the accounting, the way they recorded the account. So I've got no quarrel with the findings of the FTT. But what happened was, and you'll see this in the archaeology of its decision, because they started with this notion of, this debit's to do with consuming employee services, they focused on the debit, and when they focused on the credit capital contribution, you'll find that's further on in the judgment. They say, well, it's got to go somewhere, the credit. What I'm really looking at is a debit all to do with consuming employee services. The credit's got to go somewhere. Oh, it's gone to capital contribution. Who cares? And that's why they also said, wrongly, when I said, look, how the parent accounts for this is also very important, the FTT didn't say, well, of course it's important, because it's the parent granting the equity option that's setting all this in train. Instead, they kind of rather grudgingly recorded it. But they recorded it right. So I will come back to this, but that's why I say, yes, of course this court is dealing with this case and it's got to recharge. I understand that. The net effect of all this, which is how I'd quite like to bookend this introduction, is that there's a net P&L debit with no corresponding P&L credit anywhere, precisely because that P&L debit reflects the combustion of the capital contribution. And the recharge for both parent and the two subsidiaries is a balance sheet item, because it's a repayment of a capital contribution. It's not diminishing anybody's profits. And that debit would be the same debit whether or not there was a recharge.
You speak as if profits can be ascertained without reference to accounting conventions. The IFRS 2 tells us, it's set out at page 132 by the Court of Appeal in paragraph 12, and it tells us exactly what's going on here. And
my Lord, please may I say this?
I mean, the difficulty you've got is you're trying to tell us that that the accounting treatment of the transaction described in paragraph 7 of the accounting standard is not really what's going on at all. There is a different reality which we should base the question of liability to tax upon. But what's our authority for looking to something other than the accounting standards in order to work out what is really going on?
Let me tell you now.
Yes, that's a fundamental issue.
Yes, and I say this and the following. 1, IFRS 2, unlike all of the other authorities in the bundle that your Lordships and my Lady have got, is not to do with computing profits. And I don't accept that, my Lord. It's preserving the integrity of the balance sheet. Now, that is something which I suspect my Lady Rose is familiar with, but I think the whole court may be familiar with. Accounting, the whole approach of accounting changed over the course of the late 90s and early 2000s. So the draftsperson of accounting standards no longer had the objective of trying to measure profits. What was more important was preserving the integrity of the balance sheet, to make sure that the balance sheet showed very properly assets and liabilities. And what IFRS 2 does on its own terms, and for the minute, this is a plea, forget the recharge, for the minute, the draftsperson, which I'll show you, of IFRS 2, sacrifices the P&L account of showing any sort of reality. The draftsperson says in terms there's no outflow of resources. This debit arises whether or not there's a recharge, because we're not going to let you put this incentivization, the value of that, as a balance sheet asset. It was preserving the integrity of the balance sheet. Now, every single other case, and I'm going to come to what the authority is as to when you depart from the accounts in a moment, but that's what the objective of IFRS 2 is doing. It's booking, recording for accounts purposes, the grant of an equity option. Nothing's happened yet because it's not been exercised. You've not issued shares yet. It wants to reflect that somehow. This is how it's doing it. But it's saying we're not going to let you book the value of the incentivization of employees as a balance sheet asset. Put it somewhere else, even though nothing's gone out the company. That's what it says in terms. Now, coming then to, well, the debit's gone to P&L. When I eventually get there, what I'm going to be addressing this court on is my submission number 1. This is issue 2. Is there statutory authority? This is this question is probably one of the most important questions to do with the relationship of tax and accounts that's been before any of the courts in recent times. The tailpiece in section 46 that says, of course you follow the accounts unless required or authorized to do so by law. What does that mean? And I'll be addressing you on that. In other words, does that give courts the room for manoeuvre to not even look at the accounts because the accounts are doing something different to trying to compute profits? Separately, and this is issue 3, we get to a place where I say, well, if you say no, you don't get to ever not look at the accounts. You can ask on a more granular basis, all right, but once you've plugged this debit into the tax code, does the tax code, in the conditions it imposes, it applies for taxability on the one hand and relief on the other, are those satisfied? And that's why I say, well, all right, if you have to look at this debit, does it satisfy the conditions in section 54 of incurred or wholly exclusive of the purposes of? So that's my answer. 1, we shouldn't be looking at this account. It's not trying to measure profits. It's the opposite. And 2, all right, if you make me look at it, then we have to apply section 54 to it. And nobody's incurred anything, and not on the recharge, because this debit arises whether or not there's a recharge. I'll try not to repeat all this when I get to my accounting submissions, my Lord, but that is the thrust, and that is all. The source of all this, it all comes from what ought to be uncontroversial, that the accounting entries are generated not by the consumption of resources. The consumption of resources, it comes from the issue of this equity instrument, the issue of the option. What's being grappled with is how do we book that for accounts purposes. So I will, when I get there, show that I am being consistent. I'm not, whatever the metaphor is, doing anything bad. And we get to the right answer, which is in a circumstance where an option has been granted that's got a value, the subsidiary hasn't paid out anything. but generates a debit, that shouldn't be deducted. Even if there's a recharge and the subsidiary pays the parent for that, that's a balance sheet event. That's not that doesn't change the nature of the debit. I wonder, please may I continue with
yes,
1290? But that's why this case is important, because interrogation of the debit, that can only be done properly if you start with a proper appreciation of the facts and why it arises. Looking then at 1290, because we don't need to worry about any of that for 1290, it's tab 8 of the authorities at page 370. Now, the facts are uncontroversial. We've got an EBT for the benefit of employees, all right. This is just to frame my submissions and what I'm about to say about 1290. And this option was granted to employees of these two companies. So that's what we're looking at. So please, with the court's permission, may I look at 1290? As I say, it's on page 370 of the...
So it's common ground that there's an employee benefit scheme?
No, my lady, absolutely not. It's common ground the employee benefit trust, the EBT that granted the option, was for the benefit of employees. That's what's common ground.
Can I ask, out of curiosity, does the recharge feature in the P&L account of the parent?
No, it doesn't. That's what I said a minute ago, I think. The accounting for the recharge is, credit, investment in subsidiaries because they're reversing the capital contribution, debit, either cash if that's what they get, or a loan receivable if it's owed. So no, it doesn't. All of this is set out in the FTT decision. I'll show you. And that's the trouble, because in the courts below, nobody asked me that in interrogating the nature of the accounting entries. My lady asked what is or isn't common ground. What's common ground is that the employee benefit trust that granted the option is for the benefit of the respondent company's employees, all right? There's no difficulty there. And I wonder, please may I ask and invite the court to read section 1290 little 1 through to little 4. It's probably the most efficient way of doing it. Page 370 of the electronic bundle. Please, may I continue?
Yes, thank you.
So little 1, so this this section applies if you've got, one, an employee benefit contribution, we'll come to what that is in a minute, but a deduction that's otherwise allowable in respect of it. So that's the debit we're talking about, this IFRS2 debit. So if that debit is in respect of an employee benefit contribution, 1290 applies. It applies to do what? It applies to defer that deduction otherwise allowable under little 2 or little 3 until very broadly qualifying benefits are paid, which means there's a tax charge out of those contributions. So, and there are exclusions in little 4, which I'll come back to. But if issue 1 is actually quite straightforward, is the debit in respect of an employee benefit contribution? And if you turn the page to 1291, on page 371 of the electronic bundle, and again, as I say, I hope this is a convenient and efficient way of doing it. If I might ask the court to read 1291, little 1 through little 1 and little 2. Please, may I continue? All right, so the question is the debit in respect of employee benefit contribution? Do we have one of those? And going through the conditions of what an employee benefit contribution is, it's convenient to start off with, 1, do we have an arrangement for the benefit of put short employees? Tick. So we've got one of those. That's little 2. Second condition, do we have an act? Well, that's the grant of the option. And then we come to the question that's so far been held against me. As a result of the grant of the option, can it be said that property is held or may be used under that arrangement? Now,
so we're really, in this case, only concerned with A. We don't have to worry about B, is that right?
Exactly right, my lady. Now, the arrangement, what is it? What are the component parts of it? On any view, because it was granted by the EBT trustee, the EBT plus the option.
The EBT plus the option?
Yes, my lady. So the option granted by the EBT trustee, more precisely, the option granted by the EBT trustee, acting as trustee under the terms of the EBT, but for the benefit of employees. So that's the arrangement. It's also the act. I mean, the act of granting the option also creates a component part of the arrangement.
The option is granted direct to the employees, as I understand.
Yes, yes.
And viewed from the perspective of the trustee, it's simply a contractual obligation. It's a contingent future contractual obligation.
That's right, my lord. That was remarked upon and observed by the courts below. It doesn't stop it being a component part of the arrangement, in my respectful submission, because you're in a place where I say the component parts of the arrangement is the terms of the EBT, which inform the power of the trustee to grant the option. Even if you looked at the option in isolation, that would be an arrangement. A contractual right, of course, is right, it's true. But an arrangement simply means plan. So, whether you looked at the option in isolation or the option and the EBT together, actually, my respectful submission, it almost doesn't matter. That's an arrangement, all right, for the benefit of employees. It's contractual in nature, the option. That doesn't matter in my respectful submission. My response to the observation that it's a contract, an option's a contract, and the employees have got a contractual right under this arrangement is a respectful, a whole respectful, so what? Turning then to little a, do we have property? First, scrutinise the option. Is that property? I say yes, it's a contractual right. Is it held under this arrangement? And the option itself, let's say, is either the whole arrangement or part of it. Under simply means covered by or within. So if you grant me a beneficial option, or option that could be beneficial depending on the value of the shares, I say, well, yes, of course it is.
So you say held includes held by the employee?
Yes.
Although, if you read A and B together, that might look a slightly counterintuitive way of interpreting held in A, because B is I mean, one might, standing back, think A is about the first time property comes into the scheme, and B is about there being property already in the scheme, more property comes into the scheme. It doesn't lie terribly happily at first sight, at any rate, with held meaning held by the employee outright, rather than held by somebody for the benefit of the employee.
Looking at A and B together and saying that they must be, and saying, well, they must fit together in a coherent picture, doesn't actually hurt me, my lord, because we're in a world where what 1290 is trying to do is to defer deduction. So yes, if you look at B, it's all to do with upping the value of property and using techniques to up the rather than property being held as part of the arrangement, under the arrangement, upping the value of property. But again, my response is I don't think that matters. You look at A, you give the word its normal meaning. Held means held. What is held? Property. Are the employees parties to this arrangement? Yes, because they're grantees of the option. So as a matter of text, before we get to principle, as a matter of text, there really is no difficulty.
The employees hold the property, namely the options, under the employee benefits scheme.
Yes. And why do I say that? It's because even though the option is itself the employee benefit scheme, because it is the arrangement, that, in my respectful submission, doesn't matter. Under, in the sense of within that arrangement, covered by that arrangement, which is the dictionary meaning of under, do they hold property? Yes. It's the very essence of that arrangement that I've got these contractual rights to acquire shares if I want.
Do you also rely on the fact that, from what we see of the factual account in the FTT, the conditions that must be satisfied by the employees before they can exercise the options include conditions which relate to their employment, that they remain employed? Or I don't know whether it's they have to meet some performance target or something, but the conditions are sort of bound up with the terms and content of their employment? No.
I would say at a high level of abstraction that's neutral, but what they do confirm is that this is for the benefit of employees, all right, it's related to employment. And so what I do say is that what it shows when we get to principle, and I think this, here I do rely on this, my lady, when you get to principle, does this answer make sense? I say, I get there textually. Does this answer make sense in a world where I'm an employee, I've been granted an option, it's, as my Lady Rose has said, 100% tied up with my employment, there are forfeiture conditions, vesting conditions, all that. As part of that arrangement, do I hold my option rights as property under that arrangement? Tick, yes I do. Makes perfect sense. And I ask non-rhetorically, what's wrong with that?
So if somebody's contract of employment entitled them to a performance bonus, you would treat the employee as holding property, or even his salary, I suppose. Whatever the rights given to him by his employment contract, you would treat as property held under an employee benefit scheme.
I suppose pushed to extremis, maybe that would be true. Even that doesn't give rise to a crazy result as it happens, because all this does is defer the deduction for the employer until there's a qualifying benefit. So no, I'm not saying for one moment that a right to a salary is what you'd ordinarily think of as property held under the employee benefit scheme. What I do say is, even if you did, what does it do? It means the employer doesn't get a deduction until there's a tax charge on the wages.
Yeah, let's take it in stages. I mean, if the option amounts to what falls within this, I suppose a performance bonus payable in cash would equally fall within it.
I'll take instructions, my lord, because I don't want to answer that question without instructions. But as I say, bear in mind, this came in order to do what? In order to defer a deduction until and unless there was a tax charge. That's all. The qualifying benefits are all set out in 1292. It's in Electronic Bundle 372.
By a tax charge, you're referring then to the qualifying benefit in the hands of the employee?
Yes, my lady, I am, because the tax deduction is deferred in section 1290 little 2 or little 3, depending on when it's paid, until there's a qualifying benefit. And there are different definitions of qualifying benefit in 1292. One of them, condition A, is a tax charge.
Am I right in thinking the paradigm case for the application of 1291 or 1290 and 1291 is where the employer puts something into a trust?
Yeah.
It's held by the trust for distribution to the employee at some stage in the future. And what it does is to postpone the time when the employer can claim a deduction for having put it into the trust until it finds its way out the far end of the trust into the hands of the employee, putting it very colloquially.
Yes, and
then how can the grant by the trustee of an option direct to the employee be a putting of something into the trust in that sense? I can quite see if the shares were put into the trust and that was what triggered the debit, it would appear to be quite like one of the paradigm cases. If the fact that the employee couldn't get them for 5 years postponed the receipt of the benefit.
Response number one, that was the central thought behind what is now 1290 and originally Schedule 24 of Finance Act 2003. That's explained by Lord Hoffman, my Lord Hoffman in Dextra. However, what we're looking at is an act or an omission. as a result of which property is held. I mean, the words are wider. It used to say the payment or transfer of an asset, so exactly the sort of circumstance my Lord Briggs has mentioned. It doesn't say that now. It got changed in 2008, I think.
Well, I'm only asking what the paradigm example of the application of this section is. I'm struggling to think what how an omission might work, but the ingenuity of those who construct schemes may supply an answer.
I mean, who knows? It might be not doing something may up the value of some shares defined. I mean, if Scotland doesn't win the World Cup, for instance. But anyway, really what I'm saying is this, that might, and I actually accept, at the time of enactment of Schedule 24 was the paradigm case. We're not, even if we're outside the paradigm case, does it make sense to apply it to this circumstance? And I say the answer is yes. That's always the case when you're looking at pretty much any statutory provision. When I interrogate this provision as a matter of principle, does it make sense? Whatever its archaeology was, whatever its, the original motivation of its enactment was, especially given it doesn't say anymore payment or transfer of an asset. It used to say that. It doesn't say that now. Does it make sense to defer the deduction on the grant of something like an option? And qualitatively, it's not the same as wages, but looking at option, does it make sense to defer the deduction until there's a tax charge? In my felt submission, yes.
Yeah, I mean, there's a degree of circularity about the arguments. And if you take the view that, in accordance with the accounting standard, what's actually being debited is the services, the value of the services which the company has received, then it does receive those services in the accounting period in question. Obviously, that's what.
Well, yeah, but yes, my lord, but.
I mean, the argument's really based on the presumption that what's being debited is the value of the options, or the value of the grant of the options by the parent to. And that is employees. Exactly what is being debited, and that's how the quantum of the debit is calculated. Yeah. Which takes us back to where you started, really.
Yes, it does, doesn't it? The thing that's debited is the value of the underlying shares of the option at grant. It just is. But coming back to my response to my Lord Briggs, at the moment, it's not a figure of speech. I really can't quite see any textual argument against me about the option right being other than it's something which is property held under the arrangement, yes, being the option itself, because it's an employee benefit scheme. The fact that it's contractual, so what, so nothing. Does it lead to a result that's bad in principle? No. The debit of the value of that option, which is what it is, shouldn't be debited if it's otherwise allowable until there's a tax charge at on the other side, on the other end. And just while we're there, my Lord Briggs put to me the paradigm case of money being tipped into an employee benefit trust and 1290 being there to make sure there's no deduction until that money came out of the EBT. And the first-tier tribunal, and it was endorsed by the Court of Appeal, what it said was, yes, and the qualifying benefit has got to be made out of these contributions, and it does say that in little a of section 1290. But there's no magic in that phrase, out of. The most obvious point is if the court reads section 1294, you're told in terms that it's just a question of timing. If any qualifying benefits are provided after receipt of employee benefit contributions, they're treated as being paid out of the employee benefit contributions. There's no magic in that phrase, out of. Even before you look at section 1290 little 2 little b, which says in terms that the qualifying benefit may be the very thing provided by the employer. So my Lord Briggs paradigm case is caught by 1290. Yes, it is, but so are other things. And this is one of those. Coming also back, and while I'm at it, especially observing the point raised by my Lord Reid, that the value of the debit is the value of the option. We're not talking about the value of the incentivized services of the employees.
I thought we were. I thought that the value of the option was used as a proxy or a surrogate for the value of the consumed services.
It is, my lady, that is. But the point raised by my Lord Reid, which is where I started this morning, was that all of this is generated by the grant of the option. And it's the value of the option. And that is what's then treated as as my lady rightly says, as the proxy for what you're getting, because they're trying to find the consideration.
There's no element of deferment there. It's the then mark-to-market value of the option on the day of its grant, isn't it?
Yeah.
It may have no value in a year's time. It may be out of the money. Or it may have double the value in a year's time. But the grant of the option is an immediate benefit to the employee by the scheme. It's payday. It's not putting it into the scheme day.
Well, that might be right, but there's still no tax charge, and that's what the draftsperson of 1290 is looking at. So they've got an option. It's subject, as my Lady Rose has pointed out, to vesting conditions, all that. And then whether it's got any value at the time when they can actually exercise it, well, that's quite right, what my Lord Briggs says. I mean,
can you help with this? If the intent of the legislation was simply to say that whenever an employer makes available a benefit to the employee which is tax-free in the employee's hands, then the employer can't make a deduction for the cost of doing so. I mean, you would expect to find a very simple section that said that in black and white terms, but that doesn't seem to be what these sections are really aimed at. If there is a section that says that, you might be on very strong ground.
I'm not going to be able to respond very well to an observation that the result which I want could have been achieved by a section that did it more simply. That's true. This section started life as Schedule 24, which looked at my Lord Briggs' paradigm case. It's morphed into something else because those words pay or transfer an asset, they're not there anymore. It's act or omission. Question, looking at this section today, does it make sense to apply it to the option? Look, why should, and this is not a rhetorical question, why should there be this debit by reference to the value of the option until and unless there's a tax charge coming out the other end? And this is something done by the parent company for the benefit of the employees of its subsidiaries. There is nothing odd about this result in my respectful submission and my response to my Lord Briggs. They've got the option. Yes, they have. Where's the tax charge?
Yeah, but there's been a policy decision taken not to tax employees on options of this kind in order to incentivize productivity.
That's one of the points taken against me, and that's 1288. Please, may I come back to that? Yes, that's right.
I mean, you call it an anomaly, but the answer is that's what the act of that's been the policy underlying the tax-exempt treatment of options of this kind.
Yes. Well, number one, only on acquisition. It's the acquisition that's exempt. That's Section 475 of ITEPA. And then number two. There are certain transactions which, if the company does it itself, will not be caught by this 1290, and other transactions, because there's an overlap, between Section 1288 and Section 1290, which, yes, would be caught. And that's true.
Can I just give a totally remote example to see where we're all coming from? There must be benefits which employers provide to employees which are tax-free, quite apart from share options. So, for example, assume the employer provides heating for the offices or the premises in which the employee is working for the benefit of the employees, brackets, to keep them warm. Now, they're not, I anticipate, taxed on that benefit, so far as I know, but tell me if I'm wrong. But that doesn't mean the cost of the heating can't be deducted as an expense of the employer, does it?
Well, it has to, I mean, it's only if you're in these provisions, so there needs to be an arrangement where property is held.
No, I'm stepping outside these provisions to see where they fit into the bigger picture.
But I'll try and give a sensible answer. So you mean any old deduction by an employer which has a trading computation generally will be deductible. That's where you start. That's the whole point of this.
Regardless whether whether an employee benefit which derives from that expenditure by the company is itself taxable in the employee's hands. There's just no link.
And that's the start. That's the point of 1290. It says that's the laws absent 1290 and absent 1288, provisions of that nature. That is where you start. That's why it's looking at deduction otherwise allowable. And then it's saying, but if you've got an employee benefit contribution, then that deduction is deferred. So yes, what my Lord Briggs is saying is right. Of course, it's right. The whole point of this this provision is saying we're assuming, against me in this case, as it happens, that there's a deduction for a company providing heating for its employees, anything of that nature. That's the point. And then the question becomes, but if that is an employee benefit contribution, then the deduction is deferred. And in this case, for this option, we haven't got to the shares yet, but for this case, in this option, that counts as property under an employee benefit arrangement, and the deduction is deferred. So yes, of course we start with an assumption that the deduction is deductible. That's why Section 1290(1) says that. It is otherwise allowable. It's only if this stuff applies. And then the question is there a reason in principle to construe your way to a world where it doesn't apply? And I'm saying, no, not in this case. And then I replicate my submissions with the shares. If the options are exercised, would they be property? Tick. Would they be held by the trustee under the arrangement? Yes. So do they fit this description?
Sorry, so you're moving on now, well, an alternative case whereby the property held for the purposes of 12911A is not the option but the
Yes,
shares.
yes.
But they're not seeking the companies aren't seeking a deduction for the acquisition of the shares.
They're not, my lord, but what this provision is contemplating is, well, first of all, let me preface that. The option takes its value from the shares, so that's point one.
Well, you have to be careful which shares you're talking about. It doesn't take its value from the shares that the EBT acquires in the accounting period in question.
Well, that's true. That's right. So there's no difficulty in agreement with your lordship on that. That's right. The question then is...
But the shares are only acquired when, as I understand it, by this particular trustee, not when the option's granted, but when the trustee can see is or may be about to be exercised.
Yes, and then, if those shares aren't held, it can be said to be property which may be used under an employee benefit scheme. That's in little a2. So, what we're asking is there property, and he doesn't specify which property, and that's the point. An employee benefit arrangement might need all sorts of property which may be used, which didn't generate the original deduction, like these shares. We're looking at a world where an option's being granted to employees. It's giving them a benefit. That's why it's a good thing if and when they exercise their options. They're looking at something which will put them up on the deal.
I can see how the shares might qualify, but how does the deduction in this case for the consumption of the services, I'm at 1290 sub 1, arise, quotes, in respect of, quotes off, the shares, if you call the employee benefit contributions the shares?
There's no difficulty there at all, because the option is to acquire shares in the company. So there's an option to acquire shares. It doesn't have to be those very shares which end up being used. It says, is there a debit in respect of the grant for the option? Tick. Does that count as the right sort of arrangement? I say in response to observations from the court, yes. Does that arrangement mean shares? What you don't need is that deduction to be linked to that property. There's nothing that requires that.
Or indeed the value of that property.
No.
And yet it's, I mean, 1291, a deduction would otherwise be allowable in respect of employee benefit contributions. And you say that wording is satisfied even though the deduction is not referable to the value of the contributions, which was taken to be the shares, and it's not. Well, the only link between the deduction sought and the shares is that shares may at some point be acquired by the EBT in order to satisfy the options which represent the proxy value of the expenses for which the deduction is claimed.
Yes, but your lordship puts that to me as if that's a bad thing. Please may I put it my way. A deduction is claimed for the grant of an option to do what? To acquire shares sometime in the future. That's what 1290 is attacking. That's the arrangement. And it says, okay, we will give you a deduction for this. It is otherwise allowable. But only when there's a tax charge. And if there's not a tax charge, you don't get one. And it's
so,
very...
So the deduction can't be claimed unless and until employees actually exercise their options and receive shares. Is that right? Is that what you're saying?
Yes, and I don't see anything very wrong with that. At the moment, the whole point of this this provision is to match up the deduction and the tax charge. That's the whole point of 1290.
The benefit to the employee isn't the value. I mean, as I understand it, this option simply enables an employee to buy shares at a certain future date, subject to all raft of conditions. But he has to pay for those shares, whatever they are trading at the time he buys them. He doesn't get them free. So that the value which is being transferred to the employee is not the cost or the value of the shares, but the difference between the cost of the shares and what he has to pay for them at the, whether they're in the money. It's all to do. What the employee is getting is the in the money aspect of the option, and if it's not in the money when it comes to be exercised, it's worthless.
That's right, but what this regime does is to say, well, that even though that's right, you don't get the deduction until there is a tax charge, and there's a separate provision which is not before this court. As it happens, Section 1021, that gives a statutory deduction, what's called a Part 12 deduction, on the exercise of the option, equal to the market value of the shares. So they get that anyway. So what we're looking at here, and that was one of our complaints, because if the revenue lose on this point, there's a potential double deduction if we lose the accounting arguments. What we're looking at here, and the double deduction was acknowledged and everybody accepts there is one if we're wrong in the accounting arguments. But what we're looking at here is the grant of an option, yes, to acquire shares in the future. That's what an option is. Or at least that's what this option is. And in my respectful submission, there's nothing unprincipled and nothing odd about the proposition that the deduction for the grant of that option is deferred until and unless there's a tax charge on its exercise.
But isn't the problem with that the incentivization and the employee working that little bit harder, as represented by the debit, when that little bit harder work is consumed by the subsidiaries, that occurs regardless of whether ultimately the employee gets nothing because the options are out of the money. So the incentivization is the getting of the option rather than getting of shares cheaply, because the employee can't take back the work that he did if it turns out the options expire worthless.
But that's what the draftsperson's assuming. They're saying we know that, we understand that, and that's why the debit is otherwise allowable. But what the fisc wants is the matching of the debit with tax at the other end. So there is no difficulty at all with the proposition that the draftsperson of 1290 assumes that there are good reasons for the deduction of the debit. But what they're saying is, they being the draftsperson, you don't get that until and unless we see tax at the other end. It's a good debit. It's making the assumption against what I'm arguing later in my submissions. There's nothing wrong with that debit at the time it arose. So, consistent with what my Lady Rose has said, there's nothing wrong with that debit at the time that it arose, but it should be deferred until and unless there's a tax charge. That's the policy objective that underpins 1290.
Are these options capable of being cash settled when they're exercised?
I'll need to answer that later.
It would help if you would. Thank you. What I'm out to find out is whether the real purpose is to get the shares into the hands of the employees, or just the difference between the strike price and the market value of the shares at the time of the exercise.
I'll let your lordship know.
Thank you.
But you're then contemplating that there will be debits, which you say are perfectly fine, but the operation of 1290, I understood you to be saying, is that all those debits are postponed, though some of them are postponed indefinitely because those options will never be exercised? Or are you saying that the debit can be made when the options expire, whether or not it's in or out of the money?
Unless there's a qualifying benefit, the debit deduction for tax purposes is postponed indefinitely. That's exactly what Lord Hoffman observed in Dexter at paragraph 20. And his respectful response to that was tough. That's what happens, because that's what this is supposed to do. So the whole point of this is to say, I know you've got a deductible debit. I mean, I don't need to be told you've got a deductible debit. You've got one of those, but you don't get tax relief for it until and unless I see tax at the other end. And that may never happen. And as I say, for your lordship and my lady's note, it's paragraph 20 of the House of Lords decision in Dexter. Because I've said the policy underpinning this is not attacking the quality of the debit. The policy underpinning this is say we don't want to give tax relief until and unless there's a tax charge. That's what Parliament's done. So I say, if you look at the option rights, that's property held under an employee benefit scheme. So you've got an employee benefit contribution. If you look at the shares, alternatively, you'll have property which, insofar as these are existing shares, or even if they're not, if the trustee acquires them in order to satisfy the option, they will be held for a longer or shorter time under the arrangement, or on any view, they are property which may be used. The deduction is not for those shares. That doesn't matter. What's that got to do with anything?
Well, you say the deduction isn't in respect of the shares, but under 1290, the deduction has to be in respect of employee benefit contributions, and therefore, if you treat the shares as the contributions, then it has to be in respect of the shares. I thought you got around that issue by giving a wide meaning to the expression "in respect of."
Yeah, sorry. Typically, Mr. Bremner is making a helpful point. But no, that's not right, in my respectful submission. You've got an employee benefit contribution if there's an act or omission, whatever that might be.
Yes. Well, the contribution, the employee benefit contribution is made if, as a result of an act or omission, property is held, etc.
Yes, so that's the point. And that's the option grant. There really isn't a problem. And you can make a problem, as I say, if the intuition is either this is a good debit, the debit arises because something happened at the date of the grant of the option. But I'm saying that intuition is irrelevant because what the underpinning policy objective is to say, of course, you've got a good debit. You just don't get tax relief until and unless it's a tax charge, a qualifying benefit. And my Lord Hoffman's response in Dexter was, you might not like it. That's really not the revenues problem. That's paragraph 20.
What's the page for that?
It came loose, my Lord, so I haven't got an electronic bundle page.
Yes, I see.
Does my Lord Sales have it now?
I do, thanks.
But to actually, and this would cause the revenue, let me say, serious problems. If what this court holds is that the property that section 1291 little 2 talks about needs to be the property that generated the deduction, that could be a major problem for the application of 1292 options everywhere. Put another way, 1290 is supposed to apply to options.
Isn't there a timing problem with your approach to the shares? As Lord Briggs has pointed out, the findings and facts to the effect that shares would be acquired by the EBT if and when They were needed in order to satisfy the contractual rights of the employees. So, if that's the position, then that property isn't going to be held until...
No, but it may be used.
Oh.
Property may be used, because they're going to have to acquire shares at some... If they don't have them already...
You don't have even any identifiable property. It's just, at some point or other...
My lord, anybody who needs to buy property of a specified description in order to satisfy, say, a short sale, anything, they'll be buying property all right. So it's not any sort of weakness or unprincipled submission that I'm making to say that if I need to buy shares in order to satisfy an option that I've granted, it's going to be said that property may be used under that arrangement.
I see. So the fact that in year 5 the EBT might need to acquire shares in the parent company means that in year 1 the shares of the parent company are property which may be used.
Or may have to issue, but you will have a world. Do you have a world in which property may be used to satisfy these options?
I see.
And that is true of any option anywhere, that certainly over shares, that the shares may exist or may have to be issued.
Yeah.
And what I'm responding to in the observations that your lordships and my lady are giving me is this intuition that this is a good debit. And I'm saying I know that. I don't need to be told that. The policy objective is simply to defer it. That's what Lord Hoffman saw in Dextra. And that's why the observation that there is no necessary connection between the property which may be used and the original deduction is simply irrelevant. I will have an answer from my Lord Briggs as to whether the options can be cash settled. It's a very, very simple policy objective.
And the incentivization in this case is not, as I understand it, to encourage employees to have shares. It's to encourage employees to work towards an increase in the value of the shares so that their option gets more deeply into the money.
I suppose that's right.
Yeah.
Which, if anything, I mean, frankly, I think that's a neutral point, but if anything...
I just want to understand the underlying commercialities of it.
But as it happens, it makes the point that you're in a world where it's the option grant, that's the debit. I've said that over and over and over again. There is no tax charge, or there's no tax relief until and unless there's a tax charge that frees up that debit. And there is also the separate deduction at the time of the exercise of the option under 1021, which the employer company just gets. And for your note, it was when, I suppose I should say this, it's when it came as a shock to the Revenue and to Parliament that they thought there might be this double deduction. There was this enactment of section 1038A, and just for your note, it's tab 7, page 366 of the electronic bundle. And that says there's no deduction until and unless there's exercise. What that does tell you is that Parliament's quite clear as to what Parliament wants, that you don't get a deduction until and unless there's an exercise. So Parliament doesn't think there's anything odd. I'm just saying we don't need 1038A. And that's the reason I'm talking about the court's intuition that somehow 1290 shouldn't apply and the deduction should be given straight away. That's just wrong, or at least in the face of 1038A, it's wrong. Please, may I go through the points, there's a list of them, taken against me in the courts below. Some of them will actually pick up the points put to me by this court. And I will say it's a problem. If the revenue's having to fight this hard to make Section 1290 apply to an option, that's a problem. Because options are granted all the time, and the policy underpinning 1290 about no deduction until and unless no tax, with notions that somehow the deduction needs to be linked to the property mentioned in Section 1291, little 2, little a, that would be highly problematic. If you go through the list of the points that have been taken against me in the courts below, 1, and I think this picks up on my Lord Briggs's paradigm case, that 1290 was all to do with payments or transfers to an intermediary. My response to that is, well, that's the paradigm case. That's not what it says now. And I adopt what I say in my written case, that there were schemes, this case called OCO, which is one of those, where a taxpayer tried to get round what was then Schedule 24 by saying, aha, I'll declare a trust over my assets, so there's no payment or transfer to anybody. So you can't get me. That's in my written case. 2, the option rights are contractual. And I'm not dismissing this. I'm saying my respectful response is, so what? You've still got an arrangement. What was said by the FTT, and it was endorsed by the Court of Appeal, was, but the exercise of the option, the shares, just fructify an existing contractual right. Well, I know that. Are the options an arrangement? Yes. Does that mean rights of the option holder are held under that arrangement? Yes. Contractual rights, so what? 3, the shares, if the options are exercised, the shares satisfy a contractual right. And again, that's no answer at all to the application of Section 1291 that tells you what an employee benefit contribution is. Property will be either held or may be used under the arrangement. And under means covered by or within. Four, qualifying benefits must be provided out of contributions. So the grant of the option can't be an employee benefit contribution. Well, no, that's not right. There are examples in Section 1290, little 2, as well as 1294 have shown you there's nothing magic in the phrase out of the contributions. Again, my Lord Briggs' paradigm case, I tip £100 into an EBT, and out of that 100, they make an appointment of that to an employee. That's right. Five, this picks up on a point raised by my Lord Briggs. It's in the Respondent's case. What's said here is, if you look at 1288, that's all to do with, in its own way, matching up a deduction for the employer if the employer makes a provision, and a tax charge. And what 1288 says, I'll come to this, is if an amount is charged in the accounts, so provision, there's no relief. There's no relief for this until that remuneration is paid. It's headed up unpaid remuneration. So it's dealing with mismatches. But there's an overlap between 1288 and 1290, which the court will see. It's at 1289, page 369 of the electronic bundle. 1288 is page 368 of the electronic bundle. That tells you if there's an amount charged. You, the employer, again, it's a good deduction. Nobody's saying it's not. But you have to wait till the remuneration's paid. What does paid mean? 1289, as I said, 369 of the electronic bundle. If it's taxable, this is little 4 of 1289. It's when it's treated as paid for ITEPA purposes, section 18. Or if it's exempt income, now these options are those, because section 475 of ITEPA tells you there's no tax charge on the acquisition of an option.
No tax charge on the employee.
That's right.
Yeah.
And that counts as exempt income for your note, that's section 8 of ITEPA. What 1289 says is, yes, but even if you look at little 4, little b, it's treated as paid when, if it hadn't been exempt, it would have been treated as paid for tax purposes.
Doesn't that rather stand in the way of your overarching policy submission? I thought you were saying that the object of all this is to mean that you can't get a deduction, if you're the employer, for putting a sum of money or other benefits into an employee benefit trust, unless and until the employee gets it and has to pay tax on it. But this expressly contemplates, doesn't it, that you may get your deduction even if it's exempt in the hands of the employee once the employee gets it.
That's right, and that's a point put against me by the respondents in this case. And my response to that is, well, no. It's true there's an overlap between 1288 and 1290. If you look at 1289 little 1, the court will see that an amount charged in the accounts includes a provision with a view to becoming remuneration. So that catches, for 1288 purposes, something that could easily be also an employee benefit contribution for 1290 purposes. That's true. That's absolutely true. And what I say is that doesn't give me a problem for this reason. 1288 used to be section 43 of FA 1989. That was the subject matter of the Dexter litigation. And I've said this in my written case, and that's what's confirmed by paragraph 20 of the House of Lords decision and my Lord Hoffman. Because the revenue lost in the special commissioners, they enacted Schedule 24, which became 1290. So we're in a world where the whole point of 1290 was to cover more ground than 1288. So no, I don't accept that because a deduction for exempt income, which an employer would get if it was just 1288 and nothing but 1288, but is denied that same deduction because of 1290, that suggests I've got the wrong answer. It's as simple as that. I haven't got the wrong answer just because 1290 denies a deduction that would have been allowed if it was just 1288. And again, it's paragraph 20 again of the extra. Lord Hoffman says, look, Schedule 24, which is what 1290 became, replaced what 1288 used to be. It didn't quite replace it, it's still there, but in different form. It's a different world.
So are you saying that unpaid remuneration, which can be, according to 1289, deducted even though ultimately it would be treated as exempt income, would that apparently allowed deduction would then be taken away again by the application of 1290? Exactly,
yes, I am saying that. And I'm saying that Lord Hoffman says nothing odd about that. Why? Because 1288, that used to be Section 43 of 89, the revenue were fright earned, and that's why Schedule 24, which became 1290, was enacted to cover more ground than 1288. So the way my Lady Rose has put it, absolutely right. But that's simply because the whole point of 1290 is to cover more ground than 1288. So no, in response to my Lord Briggs, it doesn't mean I've got the wrong answer, that because the deduction would have been allowable under 1288, it's taken away again using my Lady Rose's formulation. That tells me it's the wrong answer. And it's not just me saying that 1290 is supposed to cover more ground, it's Lord Hoffman saying it. The final point that's taken against me is not really a point at all. The respondents make the point that this is not a tax avoidance case. We're not saying it is a tax avoidance case. We are saying that 1290 is there, whatever description you give, to achieve its legislative purpose, which is what? Deferred deduction until there's a tax charge. Even if that deduction is otherwise allowable. And the assumption of the revenue until this case was that you don't get a deduction for the grant of an option. But the focus of my submissions on 1290 is the same focus that I had when I was explaining the accounting of the grant of the option to my Lord Reid in particular earlier this morning. It's the grant of the option that's the relevant transaction in this case.
Can I just check, Mr. Kosh, are you saying that within the meaning of 1291 sub 2, that's page 371, the option itself can be regarded as a scheme or other arrangement?
Yes, I'm saying that. So I say the arrangement is either the option itself or the option plus the EBT. And also you'll see, as it happens, that the reason that the EBT trustee, when we get to the accounting, is treated as acting on behalf of SWHL, the holding companies, because it was guaranteed and funded by the EBT by SWHL. And that's what you'd expect. But yes, my lord, I say the arrangement whether you look at it as being the option in isolation or the option plus the, as it were, terms of the EBT, you get the same answer.
So an option given to an individual employee, you say, falls within subsection 2 as an arrangement for the benefit of persons who are or include present or former employees of the employer or persons linked to employees.
Yes, and I keep saying there's not much more I can do because I'm not sure I can take this point much further, but what's odd about that? Is it an arrangement? Yes. Do you want a world in which a deduction is deferred until there's a tax charge? Yes. Will you apply that thinking to an option? Yes. And there's no doubt, by the way, I've said in my written case that these provisions are intended to apply to options, all right. You'll find support for that in the exclusions to 1290. It's on page 370. There's reference to share acquisitions and so forth. There's no doubt that these provisions are supposed to apply to options. What you won't find is an exclusion for a deduction otherwise allowable by 1288. This is not a case where, if the revenue wins on 1290, everybody starts wondering, goodness me, where will we all be? It's the opposite.
When you say there's no exclusion for a deduction otherwise allowable under 1288, what you mean is that those deductions are not carved out of the disallowance of deductions.
Exactly. Yes. Yes, my lady, yes.
It used to be said that the taxpayer was to be taxed upon clear words, not upon the intent of the legislation.
Well, what's clearer than this? You've got property, you've got an arrangement.
Very well.
I mean, really, I don't accept that. If your lordship's telling me that what I'm saying is not clear, or if I've not been clear, then that's different.
No, but if you're right, the legislation might be thought to be rather unclear.
Well, I mean, I've got no response I can hopefully or usefully give you, lordship. There's, I can almost not bring myself to say it again, but do you have an arrangement? Tick. I'm so sorry?
Sorry, just on your submission that the option itself can be a relevant scheme or other arrangement, which I imagine is part of your case, that it's the shares which are the property that becomes used under it. Why have they used persons in the plural in the second line of 1291.2? It sounds as if the draftsman is thinking of a trust or scheme or something for a group of employees, whereas these options are, I think, granted always to individual employees, aren't they?
Yes, that's the point I was seeking to make.
Oh, I'm sorry.
No, obviously I hadn't made it clearly enough. That was what I had in mind.
You could either say, look, the plural includes the singular, that's one, or the arrangements which here would be granting options to all the employees for the benefit of a number of employees, not just one. So there's no difficulty in accommodating this, that the options were granted to more than one employee. So whether that's a global arrangement where multiple options are granted to multiple employees, which is this case as it happens. But what I'd say is not a serious point is that this stuff doesn't bite if there was an arrangement involving one individual, say a director of a small company.
But as I understood your case, it was that if you're looking at the options, then the arrangement can be, if you're looking at the options as the property, then it can be either, the arrangement can be either the option or the option plus the whole scheme, the whole trust. But then in the alternative case, if you look at the shares, then it's the shares that are held by the EBT.
The arrangement's still the same arrangement, whether you look at the option in isolation or the EBT
Sorry, it's
plus
the
the
property.
Yeah.
Yes. So the property is either... Well, if the property is the option that's held by the employee, but here we're talking about whether it's the arrangement that can...
It's simultaneous the arrangement and the rights of one of the parties is property held under that arrangement. If I grant an option, I'm saying that's an arrangement, and the contractual rights for both parties are property held under that arrangement. I don't, again, textually, there's no difficulty there.
But suppose an employer set up an elaborate scheme which involved him incurring quite a significant amount of expense. Nothing in section 1290 or 1291 would stop that expense being deductible, would it? Because it's not about property being put into or added to the scheme, it's about setting up the scheme in the first place.
Well, I'd have to think about what sort of scheme your Lordship had in mind.
Well, no, I'm just addressing your submission that the option can be regarded as the scheme. Suppose he sets up an elaborate employee benefit scheme, a trust, which costs quite a lot of money to set up, gets expensive advice from leading trust counsel and so on and so forth, tax counsel, and deducts the cost of doing that because the setting up of the scheme is a necessary part of his carrying on of his trade. Suppose all those conditions are satisfied. Nothing in 1290 or 1291 would affect that deductibility, would it? It's not what it's aimed at.
If there's a debit, and there needs to be an arrangement which is in respect of an employee benefit contribution. So if it's in respect of...
Yes, but it's not the the point I'm getting at is that the scheme and the contribution to the scheme are two conceptually different things.
Well, I want to tread carefully, so I might end up taking this back because I'll take instructions. But if in fact what your Lordship is putting pressure on is the phrase in respect of, because looking at the phrase employee benefit scheme, absolutely that just means the arrangement, however elaborate, I don't care how elaborate it is, which is for the benefit of employees, which I paraphrase contemplates that property will be held or may be used under it. So you've got one of those. And yes, absolutely, the cost of setting that up might be a lot.
Would that be taken out by little 4A, 12904A?
Well, it might be, or it might be a qualifying expense, which is defined in 1296. If my lady sees a qualifying expense, you get a deduction not just if there's a qualifying benefit, but also a qualifying expense. And that's all to do with the scheme manager, which could be in the employer, incurred in operating the employee benefit scheme and would be deductible for CT purposes.
Which section was that?
1296, my lady. Little one. If the court has it.
Yes. So that envisages that the employee benefit scheme is something which would be operated by a scheme manager.
Yes, but scheme manager is defined as anybody who's operating the scheme.
Yeah.
So that could be the employer, it could be anybody.
Or, in this case, the EBT, I suppose. Is that the person who, in this case, administers the employee benefit scheme?
It could be the EBT trustee plus the holding company.
Well, they can't both administer the scheme, can they?
I don't see why not jointly. If they agree between them that the EBT trustee says, I need to make sure that you give me access to shares if I need them to, because somebody's exercising an option. The point I'm making, I mean, it's a moot point. The point I'm making, in answer to my lady, and also in answer to my Lord Briggs, we're in a world where you get your deduction if there's a qualifying benefit or a qualifying expense. And otherwise, no, you don't. It's deferred. And the intuition that there's something wrong with that is the intuition which I respectfully say is an intuition we are not permitted to have. And 1038A confirms that.
1038A is completely irrelevant. It's enacted subsequently. It can't possibly be a guide to the meaning of the language of the 2009 Act. It wasn't enacted till 2013.
The only point I'm making, my Lord, and it's similar to the approach of my Lord Hoffman when he looked at future legislation by the by, is that the proposition that there's something wrong with deferring the deduction, perhaps indefinitely, that is absolutely not true. And certainly from 2013 is not true. And I do get to say that. And actually, that's what Lord Hoffman thought. You're not bound by Lord Hoffman, I'm not saying you are, but that's what he thought was the case even on the old legislation, in a world absent 1290. Now, all of these points which I've addressed were made one way or another in the courts below. I think it would be more efficient if I simply gave you a note of where you'll find those. The FTT, it's at paragraphs 98 to 101 of its judgment, pages, these are pages in the electronic bundle, 201 to 203. The upper tribunal didn't analyse any of this at all. It simply agreed with the FTT at 113 of its judgment at page 172. And then the Court of Appeal, paragraphs 77 to 79 at page 144 of the electronic bundle. And the FTT decision, which was actually endorsed by the Court of Appeal, that picked up all of the points made by this court. And the observations made by this court tapped into. So, for example, it said, but let me get the words right. As a result of the option, can you really say, and that's my Lord Reed's timing point, property is held? And I'm saying, well, maybe I can, maybe I can't, but I can certainly say as a result of the grant of the option, property may be used. They all tap into this intuition, which I say is simply wrong, that there's a deduction otherwise allowable, this deduction, should not be deferred until and unless there's a tax charge, which may be never. And that's why textually, to say, well, this only applies if there's an intermediary, that doesn't say that, doesn't mean that. This legislation only applies if the deduction is somehow linked to the property you're talking about in section 1291, little 2, little a. No. Can you restrict little 2, little a by little 2, little b? No, why would you? Why would you want to?
Mr. Kish, did you advance the submission that the option itself could be the relevant scheme or arrangement in any of the courts below? Yes,
the Court of Appeal said I didn't, but that's not right. I did. It's in the transcript. And nobody listened. I say these points made against me are defective in analysis. They don't respect the text, and they're advancing an intuition, which I say is in the face of what these provisions are trying to do. And that's whether you look at 1288 or not. And by the way, all of my submissions are exactly the same whether you look at the recharge or not, whether you glue that on as a component part of the arrangement. Just give me a moment. I'm going to check because those are my submissions. But before I close my submissions on 1290 and move on to the accounting, I just want to check that nobody's got anything else. No, that's the lot on 1290. Please then, with your permission, may I move to the accounting? Because 1290 is relevant if and only if I'm wrong about my accounting submissions. But where the damage has been done in my respectful submission by the courts below is to restrict 1290 with as a payment or transfer of asset to an intermediary. It doesn't say that. And that is problematic for the revenue. Now, I wonder if I could usefully use the time leading up to the short adjournment by dealing with the, now moving on to my accounting submissions, dealing with what I want to call the archaeology of the debit. Because these accounting submissions, the P&L debit, and they've been usefully, if I may say so, trailed by the conversation I had with the court, and in particular my Lord Reid earlier this morning. I'll reprise, I'll take it short, but where this debit comes from is critical to my accounting submissions. If you start from the proposition that I've got a debit and it represents consumption of employee services, and that's the focus of my attention, that's the focus of my analysis, and I then do not respect why this debit arose, how it was accounted for, yes, I have a problem. And I don't want that. So what I'm going to show you, with your permission, is what I'm calling the archaeology of the debit and the explanation of the drafters of IFRS 2 as to why this debit appears. And what I'm going to show you, as I say, is that if a company issues this equity option to incentivize its own employees, what's said is, we, the drafters of IFRS 2, want that grant, even though nothing's come out of the company, recognized as a matter of accounting. We will treat as consideration for the grant of that equity option the incentivization of your employees, because they're the ones who've got it. But we are not going to let you treat that as a balance sheet asset. The debit goes to P&L, recognizing no outflow.
Recognising the...
No outflow, no economic cost. Because nothing's happened. The options may never be exercised. A lot of these weren't. In this case, because it was treated as being granted by the parent, I've said parent treated, and the accounting, yes, liability, because you might have to issue shares, liability to equity, credit equity. Debit, you're making a contribution to your subsidiaries. Subsidiaries say, thank you very much, credit capital contribution, debit what? Incentivization of our employees, not allowed to book that as a balance sheet asset, debit P&L. No recharge yet, nothing. That's the accounting. Recharge, repay that capital contribution. And as my Lady Rose has said, and this is right, the quantum of the debit, because you can't really easily quantify it at all, a value of the incentivization of these employees is a proxy. What is that? It's the value of the option. What's that? That's the value of the underlying shares at the time of the company, which may, of course, of the issuing company, that's the parent.
Would the value of the option not represent the difference between the current value of the shares and the purchase price stipulated in the option?
Well, that's true, but what my Lord Briggs called at the date of grant the in the money element would be reflected. That's right, and that's reflected in the FTT decision. So that's that's the reason I am saying that when I'm looking at issue 2, what's IFRS 2 doing? It is not looking for a way to compute profits more accurately. It's looking to preserve the integrity of the balance sheet. And that's why, when I get to issue 2, I'll be saying, is there any statutory mandate for the court to say, in that world, we shouldn't be even looking at these accounts? Or even if that's wrong, in construing words like incurred wholly exclusively, the phrases in section 54. Realizing the nature of this debit.
So what is the defining characteristic of a debit in the P&L account which is not there in order to enable more accurate computation of profits, but is there to preserve the integrity of the balance sheet? How do you distinguish in the debits on the P&L account between those that are there for the first purpose and those that are there for the second purpose?
Because, and I'll show my lady this, because you're told that you've received a capital, you being the subsidiary here, received a capital contribution in the form of incentivizing your employees. So that's what you're getting. It's a receipt. But it's a receipt which, because it's a sort of receipt that you can't, it's got no lasting value. We're not going to let you show that as a balance sheet asset. So the debit has to go to P&L.
So it's any debit which is there to match a capital contribution in the balance sheet.
If it's, well, I don't want to make a more general submission than I ought. It's certainly there where the debit reflects the consumption of a capital receipt because of the nature of that very receipt. What you're getting is your employees are being incentivized.
So yes, I understand that. Yeah. I'm just trying to abstract it from this particular instance. So let me just. So it's where the debit is the consumption of something which is treated as a capital contribution.
Yes, you're given something, and I use the word combust on receipt. On receipt, it's not like getting gold bars or cash which you then spend. The very receipt of them is also to consume them.
You know, are you trying to argue that a P&L account prepared in accordance with the accounting standards doesn't provide true and fair view of the company's profits.
I'm not trying to argue that at all. I'm saying that it's self-fulfillingly true and fair because that's what IFRS 2 tells you to do, but it does not match commercial reality. And then the question is, having then identified that...
Was this the subject of expert evidence?
Yes, and I'm going to show you it. And that's what I'd like to do now, with your permission.
And I mean, we're no longer in the. Am I right in thinking are you going to take us back to the? I mean, the starting point is that you tax profits on the basis of accounts prepared in accordance with the relevant standards, subject to the proviso, except where the law requires a different treatment. So I'm really wondering where we're going with this. Are you going to bring us back to other provisions under which the law requires a different treatment?
Yes, I am.
Yeah.
What I'm going to say is this. Section 46 says, compute profits in accordance with GAAP unless the law requires or authorizes otherwise. It's a very odd phrase.
Yeah.
And we have to ask, where does that mandate come from? What does it mean to authorize? And what I'm going to say about that is, given that Section 46 represents a codification of the pre-Section 42 FA 1998 case law, the cases, and Lord Bingham's judgment in particular...
The whole point for codification is you don't go back and look at the pre-codification cases.
I'm so sorry?
The point of a codification is to relieve everybody from the need of going back to an exercise in legal archaeology.
Well, no, I don't accept that in the light of what Section 46 says, which is to...
It's Farrell and Alexander. I mean, unless there's some problem about understanding the codified legislation, when you can go back and look at the earlier legislation to resolve an ambiguity. In principle, you don't look at it.
Yeah, this is a conversation which my Lord Sales is very familiar with. It came up in a case called Benteen and Benteen, which was then referred to in Derry, which is this: absolutely right. When you're looking at a consolidated act, a statute, you need a reason, a justification for looking at the pre-consolidation legislation. When you're looking at case law, that has authoritatively decided what a particular pre-consolidation provision means, that case is just as good and just as binding post-case law, post-consolidation. Where that takes me to is this, is one has to ask, what is that tailpiece, except as otherwise authorized or required? What's it doing? My submission is, it has to be, first of all, it has to be doing something. It's not a waste of ink. The explanatory note tells you it's there to preserve the authority of the pre-codification case law. I really don't want to go to it just now because I need to show you the archaeology of the debit. So no, I don't accept that you can go to you can't go to pre-consolidation case law. I think you can and should.
Yes, I had in mind, I thought you were going to take us, as you do in your case, to the pre-consolidation legislation.
Well, I do, but only to say it does the same, Section 46 is doing exactly the same thing in exactly the same way.
But the archaeology, as you say, of the debit is relevant, I think, in two respects in your case. First, because you say it informs how one construes the terms expense and incurred in Section 54, and it's really only if you fail in that submission that you have then to fall back, as it were, on the tailpiece to Section 46. Would that be a fair way of...
It's one way of putting it. It's neither fair nor unfair. The reason I've taken it the other way around is because this is not just important, it's a fundamental point as to whether the courts ever have a mandate to depart from the accounts, to not even look at them. So, yes, you could put it that way, my lady, of course you could, to say, well, I only need what I'm going to call my fundamental point if I lose on Section 54. That's true. But as a matter of chronology, this point is so important as to, is there ever any statutory mandate for the court to not even look at the accounts in the first place, because they're doing something different, doing something other than trying to compute profits? And if so, where is that mandate, and what's its content and scope? That's why I'm taking that first. That's why it's issue 2. Now, I wonder, please may I do this? IFRS 2, in this case, it's in the core bundle, the core volume. It's that electronic bundle, page number. It starts at page number 287. And I'll take it short, but this is very, very important in my respectful submission. And you'll see that the introduction at 1 and 2, it's dealing with shares and share options to employees.
The principle in Farrell and Alexander extends to case law as well as the previous legislation. Lord Wilberforce makes that clear. So you have to find some ambiguity in order to justify going back and looking at previous materials.
Yeah, I didn't want to take up time on it, but I think that's what I said in the Benteen case. It was Lady Arden that thought it might be more qualified than that.
Exactly. Could I please deal with this point when I get to looking at the cases, because the authority and weight of pre-consolidation cases, and in my world, in our world, in the tax world, where there's consolidations all the time, is a very important matter, even before you get to questions of the rewrite. So I absolutely will deal with this point, and
I'm just to make the point. I mean,
yeah.
the logic of consolidation must equally apply to previous legislation and case law. As my lord says, the point of it is to spare people the agony of going back through what may be decades of previous observations, cases, and so on, and they just have an authoritative text in the Consolidated Act.
Well, let me just trail what I'm going to say about that, and I hope this is helpful. I understand about consolidation. The whole point of consolidation is to allow you to look at the Consolidated Act and not at the pre-consolidation legislation. When it comes to pre-consolidation case law, just to make sure we're not talking about different things or at cross purposes, a case like Malilio and Drummond, I say, is equally good, even though it was looking at the 1970 Taxes Act rather than the 1988 Taxes Act, or now you're looking at, whether you're looking at ITOIA 2005 or whether you're looking at what we're looking at, Section 54 of the CTA 2009. And not just because it's construing the same words, doing the same thing. And so it's, as a matter of stare decisis, if one interrogates what stare decisis is trying to do, and so I'm not talking about going back to look at pre-consolidation legislation. I'm simply asking, does a case which decides authoritatively, say it's the House of Lords case, pre-consolidation legislation, is it still good post-consolidation? And I'm saying yes. Because stare decisis, it's all to do with a superior court binding an inferior court. And that's to do with the intention of Parliament as to what court Parliament considers is a superior court and an inferior court. And if that's the key, then Parliament's intention in consolidating absolutely might be to ask you to look at the Consolidated Act and not pre-consolidation legislation, absolutely. But it is doing so knowing that the pre-consolidation cases have decided these provisions. So as a matter of parliamentary intention, Parliament would have intended these cases to stay good, because it is just a consolidation.
I'm not sure where all this is taking us, but I would have thought that with the consolidation statute, the relevant authority is that of Parliament expressed in the Consolidation Act. It's intending that that shall stand as the authoritative statement of the law, whatever was decided previously.
There's a different principle, which is the principle that if wording is carried forward from one act to a later act, then authorities as to the meaning of that earlier wording are treated as applying to the new wording. What I'm not sure about is whether when you have a consolidation, the consolidation is supposed to incorporate in the new wording the case law that affected the old wording, so that you don't need that other principle which is more generally dealing with when wording is carried forward from.
I'd say that's right, and I've got submissions to make on that, but if I could trail what I'm going to say, which is that the proposition that a consolidation does away with the old case law, so you've got to start again, that I say is simply wrong. What I do say is that if, and this is using my Lady Arden's words rather than mine, but the text and the essence of the provision stayed the same, both pre and post consolidation, an authoritative decision retains its weight, its authoritative binding quality. And so
I might be an outlier about this, but I would need some persuasion that that is the effect of a Consolidation Act. I mean, just so you know, my understanding of it, which might be wrong, and you may show me that it's wrong, is that you start, where there is a consolidation statute, you start with the consolidation statute, read it as a whole, as you would any act. If doing that, there is no ambiguity in the particular provision, one stops there and applies that statute. There's a subsidiary presumption that if there is an ambiguity, then you go back to the previous case law and well, actually, it would be the previous case law rather than previous statutes, because you need the cases to tell you what the previous statutes meant.
Quite, and this is exactly the debate that my Lord Sales had with my Lady Arden in Benton and the authoritative nature of whatever that case was, Ray Clark. But
well, again, just so you understand, that's my understanding of what Farrell and Alexander said, which is the root.
Which ultimately is a more important authority than a decision of a court of appeal.
Yeah.
Yes, so it is. But can I come back to this point, because I will need this point when I get to my submissions as to the extent to which the courts below, not this court, but I'm not saying that, but the courts below should have been bound by some of the decisions I relied on. And I say that because I'm commending those same cases to this court, which isn't bound by anybody, to say, well, and they made sense as a matter of principle. So it's correct that the decision that this court takes on this question of the authoritative nature of a decision on pre-consolidation legislation, post-consolidation, is very, very, very important to everybody except for this court. So it is important. And I understand it's important. I will make submissions to
all right, thank you.
Reinforce what I say.
It was affirmed. I got a ticking off from the I think it was the Supreme Court, or no, it may have been the House. It was the House of Lords in William Grant. You'll remember the case of William Grant, and I think in that case, Lord Neuberger described my reasoning in the inner house as an exercise in legal archaeology, which I shouldn't have embarked upon because of Farrell and Alexander. So as well as Farrell and Alexander itself, in the tax context, the William Grant case may be relevant. Yeah,
my recollection, I mean, we'll have to look at it. My recollection is Lord Neuberger and Lord Hoffman were actually very nice about your Lordship's dissent in William Grant.
Well, they were, but I was regarded as having been rather too enthusiastic in looking at old authorities.
Well, there you are. We all do it. But what I do, can I please park this point, because I need to show you where this debit comes from to make good the point I'm making, that what you're looking at is grant of the option before you get to look at this notion of consumption. And although I've got time, I don't want to rush it. So I will come back to this point with the court's permission. Please.
Can I just check one thing you said, it's now some time ago, in your archaeological introduction? I don't mean at the beginning of this morning, I mean about half an hour ago. You said that on the grant of the option, the tax-paying companies recognise a balance sheet credit consisting of a capital contribution by its parent.
In this case, yes.
At which I think you were just about to go on and say was sometimes where there was a recharge reversed out. Then I thought you were saying, actually, what is there being recognised isn't so much the grant of the option, but the benefit of the services of the employees. I just wonder if you could help me by, as it were, nailing your colours to one or other of those masts.
What I said, and I'll show you the accounting for this.
I mean, I have been looking back in the FTT's
Yeah.
detailed analysis.
And I'm going to go to that.
Good.
The grant of the option, so please, for the moment, forget the recharge. The grant of the option by a standalone company, so I'll take the simplest case first, and then we can build on that analysis for this case. A standalone company that's got its own employees issues an equity option. What IFRS 2 says is, you've incentivized your employees, credit liability to equity, that's true, debit, I'm repeating now what I've said, you don't get a balance sheet asset, debit P&L. So that's, I've only got one mast, because when you come now to a parent company doing that for its subsidiaries' employees, what you've got is the parent company saying, or IFRS 2 telling the parent company, you've made your subsidiaries more valuable by incentivizing their employees. So the relevant accounting there is still credit liability to equity, because it's you that's going to have to issue the shares, but you do get to recognise a balance sheet asset because you've increased the value of your subsidiaries, debit investment in subsidiaries. The subsidiaries say, well, thank you, parent, you've made me a contribution by agreeing, by issuing this option. Capital contribution, credit capital contribution. What's my debit? You've incentivized my employees. I don't get to book that as an asset, debit P&L.
No.
That debit stays on the recharge because the recharge says, they made you a gift of 100, it's combusted, but...
So, I mean, I think your answer to my question is that the capital, what underlies the capital contribution that's recognised in the accounts of the tax-paying subsidiary is the grant of the option.
Absolutely right.
Yeah, thank you.
Absolutely right.
That's fine.
So even in your simpler case of a standalone company granting options to its employees, it would have to credit the liability to the balance sheet and debit the consumption in the way that it does now. And you say that in that simple case, that debit would also not be allowed as a deduction.
Yes, I do say that. Absolutely. Because the draftsperson of IFRS 2, they're recognised as nothing's happened. There's no outflow of resources. I wonder, I've got 8 minutes. Can I show you this material, which is important, and then I'll pick up again after the short adjournment with your permission. Yeah. So, did the court actually look at the introduction I showed the court in IFRS 2? You've seen that. Then, the critical paragraphs in this case are paragraphs 7 to 9. They're on page 291 to 292. And if I could take these short, because they are explained. Paragraph 7 tells you that an entity, so this here will be the respondent companies in this case. They need to recognise goods or services in a share-based payment transaction. That's what this grant of the option is one of those. Now, in this simple case that my Lady Rose has just outlined, the equity, so this is a company with its own employees, the entity shall recognise the corresponding increase in equity if they were received in an equity share-based payment, or liability if the goods or services are required in a cash-settled share-based payment transaction. Put short, if you are granting the option and what you're getting is incentivized employee, you are recognising a liability to equity. Then it's paragraph 8. When the goods or services required or acquired, so this is the incentivized employees in a share-based payment transaction, so you've granted your option, you're getting incentivized services, do not qualify for recognition as assets, they shall be recognised as expenses. This is the beginning of the trail of saying this is all to do with preserving the integrity of the balance sheet. 9. What 9 says, put short, and the court, of course, can read this for itself, and your lordships and my lady can read it for yourselves without a gloss put in it by me. What they're saying is, if you're consuming something on receipt, if that's what's happening, then you treat it as an expense. It's consumption, it's not expenditure. It's treated as an expense. Now, just to make good one point, on page 227 of the electronic bundle, this is the expert report of Mr. Henworth. And at paragraphs 4.9 and 4.10, he explains why, although it was the trustee that granted the option, nevertheless, it's the holding company treated as granting. It was treated as granting the option. It established the EBT. The EBT was funded and guaranteed by the holding company. Its activities were conducted, this is an accountant speaking, on behalf of the holding company. Now, please, may I move to the explanation, what I've been telling you about the application of IFRS 2 to the first-year tribunal. And that's page 174 of the core bundle. I wonder, really because I've only got 3 minutes, I wonder if now might be convenient to rise and I'll pick it up again after lunch.
Yes, I should mention, just in case I mislead you, that that the passage I had in mind in the House of Lords where legal archaeology had been deprecated was actually an appeal called Scottish Widows and HMRC. Lord Hope at paragraph 15 and Lord Newberger at paragraph 123. The William Grant case doesn't deal with that point, but it is a case about the importance of accounting standards.
I remember Scottish Widows and William Grant. If I use up the 2 minutes I've got left, what I'm going to be showing you this afternoon, after I've made good my point about the accounting, and I'm making a respectful submission. I mean, no discourtesy to this court at all. It would be very, very wrong to dismiss my fundamental point of, look, there are times when you shouldn't even be looking at the accounts if the accounts are trying to preserve the integrity of the balance sheet rather than computing profits. And every single case I'm going to show you in the authorities bundle, including William Grant, they were all to do with accounting standards trying to compute profits. It wasn't an analogue to what IFRS 2, what I've just shown you, to that. Please may I leave it there and pick up after lunch?
Yes, certainly. So we'll adjourn now and resume at 2 o'clock.